Hello, welcome to episode 39 in our Navigating Turbulent Times webinar series. I'm Jenny Thomas, Head of Marketing Communications at IWFM. For this week's webinar, we've again teamed up with our friends at Make UK, champions of UK manufacturing and engineering, to bring you the second of our 3 spring briefings on key challenges to the business and legal operating environment happening in 2021. So the change we're focused on today is all about crossing borders. EU borders to be precise. We've got Brexit done, the transition period has ended, and we have a trade agreement with the EU. Now, we've been in lockdown since the start of the year, so it might feel as if nothing much has changed, but we've all heard the stories about queuing lorries, perishable goods, and paperwork puzzles. They've been about goods crossing into and out of the EU, but what about people coming and going, especially for work? Well, we are very fortunate to have 2 experts on hand who are going to help us navigate these new rules. I'm delighted to be joined today by international mobility consultant Alice Tranter and Head of HR and Legal at Make UK's London region, Lucy Atherton. Now, between them, they have over 40 years' experience, respectively, in EU law on the topic of international mobility and using human capital throughout Europe, and as a specialist employment lawyer. They're here to give us an introduction and overview of the new EU scene, what's changed, what it all means, and crucially, how to get more help. So a very, very warm IWFL welcome to both of you. Firstly, Alice, I think you're going to lead us off on the new arrangements around the movement of people now that we've left the single market. We'll take a short break for questions after your session. Then Lucy, you're going to focus on the new immigration rules coming to and working in the UK, and we'll take questions as usual at the end. So please do post your questions in the chat. We will get to them in some shape or form. And Alice, it's over to you.
Thank you, Jane, for the introduction, and thank you to everyone joining us today. I'm just going to turn off my webcam so it's not distracting, and we will begin. So my section is outbound travel, people travelling to the EU. But firstly, in the context of Brexit and the trade deal, and what does it mean in terms of the movement of people, and I'll be going on to explain how this will affect UK companies. So the UKEU trade agreement, this is our starting point, because before we even get on to do I have workers that need to travel or anything like that, it all starts with this brand new UK-EU trade agreement, which sets out the rules for services and trade, which obviously umbrellas people element of that. So the transition period has ended, there is a new deal, and the movement of people and single market access is affected. So we were previously in the single market, now we're not, and that's why we've got new regulations and rules that either restrict or change the way we provide a service in the EU. So as I just said, the single market is a market within the EU only, and it regulates the provision of services, including movement of people. Because we've now left the single market, essentially there is no automatic access to it. This is why we have to refer to the new trade agreement to see what can I do as a UK company in a certain sector or industry in order to continue operating as I am. So UK companies will have to refer to the trade agreement because there may be new restrictions in there for certain sectors in terms of operating. There may be a new restriction or provision depending on the country. So the trade agreement does include all the sectors of the economy, it's cut up to about 18, and each EU country will have added a regulatory provision or more on how to operate in that sector in their country. An example I like to give, if you're in aerospace and you've got business in France, you will need to find aerospace sector in the trade agreement and see whether France has added a provision in to say, well, in order to continue operating as you are, you will need to do X, Y, Z. If there isn't a provision provided by a country under your sector, it's fair to assume you can carry on as you are because there's been no added restriction or no added limitation. However, what we would urge is that you check the national website for that country under their trade and services section in any means to double check whether there is no restriction. So we always have to start the trade agreement because there will be differences and changes perhaps to your sector that you operate in terms of continuing to provide a service in the countries that you do. So what can you do? When I say check the trade agreement, it's not like flicking through a magazine. It's quite a long piece of text. It's 2,000 pages long. However, it will be in the trade and services chapter. So it's quite easy to see that it is cut up into sectors. Each sector obviously will have different activities. So under engineering, for example, you'll have civil engineering, electrical engineering, and so on. And these sector-related activities have a code, and this categorizes your company's activities, and then you're enabled to find the applicable rules. So as I said before, each country will have different provisions. France's will be different from Germany's, for example, and so on. And as a UK company, you will need to identify continued access to think about sending anyone to work with you. This is your starting point. So firstly, can I continue to and then I can think about, right, what do I need to do in order to send my workers there? So within the trade agreement, there are many other provisions that I will go through today, including social security obligations, which effectively is your national insurance payments, and definitions of the worker. So what type of are you a business visitor, or are you actually providing a service? Note, whilst this is a legally binding text, of course it is, there are some general caveats which I'll go on to in a second. But what is really important is that the trade agreement has clearly indicated that individual member state rules take precedence if they're incompatible with the trade agreement. What I mean by that is, if the trade agreement says something such as a business visitor can do this, but Germany says, hang on a moment, according to our rules, we don't allow people to do that activity as a business visitor. That person actually needs a work permit. That would take precedence over the trade agreement. Member state law takes precedence over the trade agreement. So not all of what is in that chapter will be adopted by member states as their own rules come first. So again, it is very much on a country by country basis. So the general exceptions, which I just referred to, so individual member state rules on working conditions, minimum wages, collective agreements continue to apply overriding the trade agreement. So this is again is another caveat. When you send your workers to the EU, remunerated employment or providing a service as per a commercial contract, whichever it is, whilst they are in that country, local labour law applies. And local labour law, as you might understand, will be how many hours a day they can work, what they must be paid. And this is all found in a collective agreement for that country, which will be negotiated between a trade union for your sector and an employment organisation such as Make UK. We used to do collective bargaining back in the day, no longer do we do it, but we were the type of organisation that would negotiate wages and working conditions for people in our sector. And when I'm talking about minimum wages, effectively, if you're an engineer going to Germany, you're going to do work for 5 days, you will need to be paid the same going rate as a German equivalent engineer, or above, whichever is higher. So bear that in mind. Unless otherwise stipulated, rules on entry and temporary stay of people continue to apply. Within the trade agreement, each member state and the UK can impose their own border control measures and impose visa control on travellers unilaterally. You'll hear from my colleague Lucy later on the UK side of things, but it's very clearly stated in the trade agreement that both the EU member states and the UK have the power to control their border, which means we can come up with anything we like, essentially, in terms of border control measures. So we can require incoming business visitors or workers to either get a visa or many documents at the border. It's the same going outbound as well, and it will be different. So instead of seeing the EU as a bloc, we've now got 27 different countries, 27 different immigration systems, and 27 different entry requirements for all of our people moving, which is quite a lot. So it's really important that we think very unilaterally now. So they've got the power to impose their border control measures as they wish, and to impose visa requirements where appropriate. So that is not a product of the trade agreement, that is us leading the single market, and each party having the power to impose these measures as they wish. And it's very explicitly stated in the trade agreement. None of the rules on travel apply to public procurement. So if you've got a contract with the public sector organisation, these don't apply to you. There are very separate rules for that, which are quite complex, but we're not going to look at them today. Where there is a commercial contract in place between a UK entity, a UK business, and an EU entity, the applicable law is the place where the contract is signed. So if you go over to sign a contract in Germany, German law will apply, and vice versa if someone comes over to the UK and signs it. So movement of people. So that was about the trade agreement. Starting point gives you an idea of whether you can continue operating as you are, or whether there are new restrictions you need to be aware of, and some general caveats as well. So now we can get on to how can people obviously go and provide a service in EU or generally visit as a business visitor. And I will also cover the different definitions in a moment. So as you can probably imagine, the trade agreement does not make travel easier, and we're talking about business travel here. We cannot get a better deal by leaving. So the fact that we've got a trade deal is a good thing, and it signals that everything is fine and that nothing's going to change because we've left with a deal. Unfortunately, that's not true. It's great that we've had a deal, but it does mean a lot of change, as you've probably already seen. So a little bit of context. When we were a member state of the EU and within the EU now, business travel is already regulated, and although the UK had a very low level of awareness of this and didn't comply, it's not a brand new thing. Business travel or providing service or being posted to work somewhere else is highly regulated in the EU, and they take it very seriously. So by leaving, we cannot receive more favourable treatment than these rules as a benchmark. So if existing EU countries have to comply with business travel rules, then we're at a minimum are going to have to comply with the same ones, if not more onerous. So we're never going to get a free entry, off you go and do some work without doing anything. We've got to get in the mindset now that we are going to have to comply with individual member state rules when we send our workers there. So as you can probably imagine, UK workers no longer have a right to work throughout the EU as they formerly did. UK workers can no longer travel to different member states in a single trip as they formerly did. This will be more complex. If you go country hopping, for example, you will have to notify each country in advance before you go. And doing multiple countries in the same trip makes things very hard. So a lot of preparation is needed before you do send any workers or travel yourselves on business. EU travel regulations continue to apply, and as I said, they are individual member state national law. As I said, EU countries, or the EU really, take this incredibly seriously, and if your UK workers are found to breach these rules, they are effectively breaching the law, and the sending company, and possibly your client or the receiving company, whether it's a supplier or not, could both be liable. So it's not a frivolous thing. This is very serious. This is EU law. So general caveats on people, as I said again, and I do want to labour the point, but the trade agreement cannot give the UK better or the same access to the EU than any other member state. So if you're going from Germany to France to do some work, you have some rules to comply with. The UK is obviously going to have to comply with those existing rules or much more onerous ones, to be honest, because we cannot get better treatment than an EU member state. So firms established in the EU, they've got to comply with basic labour market rules, as I've just said, as still do UK firms. So if you are providing a service in an EU country, you will have to comply with that country's labour market rules. And as I said before, this includes paying your worker the minimum wage there and complying with collective agreements, which includes details on working conditions. As we might have seen in the news, the UK has also committed to continuing to maintain current labour market and health and safety rules, but we may diverge in the future. We may not have to adopt future EU-wide labour market rules. So workers, what do I mean by worker? Well, the trade agreement has provided 4 different categories of worker. However, the rules around providing a service or working in general in the EU will all be subject to individual member state rules. So we've got business visitors for establishment purposes, contractual service suppliers, which is probably the most common one, which is when you send a worker to provide a service to your EU client as per a commercial arrangement or commercial contract. We've got independent professionals who are self-employed or contractors, and then we've got our ICTs, our intra-corporate transfers, who are secondments. As I've mentioned, all the above have different rules. For example, the length of workers' employment, their qualification and type of contract. In most cases, if a UK national is to undertake work, remunerated employment, they're likely to require a work permit and or residence permit locally, depending on the country. This is in addition to notifying the country in advance and complying with local labour law. So as you are starting to see, there's lots and lots of factors that affect business travel going forwards, not just your permit, but other things as well. So business visitor for establishment purposes, this is when someone is allowed to enter an EU member state without a visa or permit for the sole purpose of setting up a business. It's probably not the most popular category, but it's a category that the trade agreement has identified as a worker. So if you're going to establish a company in the member state, you're allowed to do so as a business visitor, i.e. not requiring a work permit. Independent professionals, as I've said, it's an umbrella term for personal service companies or self-employed or contracts, and it affects people established in the UK only. So if you're an EU contractor, it doesn't affect you. And it does include agency workers as well. So brand new barriers to this group. If you're a company or self-employed people, they are going to hit a barrier, because if you are self-employed or you're a contractor, you cannot provide a service within the EU unless they contract with the final consumer, i.e. you cannot subcontract them out. So if you do use contractors to provide a service to your client, you can no longer do that. They've got to be contracted to your client, which effectively cuts you out the picture, which is not ideal. So you either have to employ them, or they have to establish themselves as a self-employed personal service company in an EU member state. Further, if they do contract with the final consumer, the contract cannot exceed 12 months, and they must hold at least 6 years professional experience in the relevant activity. So these are brand new limitations. Contractual service supplier, we used to refer to this category of worker as a posted worker. We've dropped that terminology now because that's an EU term. The trade agreement has provided us with this new term, and we refer to it as CSS. So as I said, broadly speaking, new definition of what we call a posted worker, but it is only for employed workers. You have to be employed. It doesn't include the self-employed or agency workers. And to fit this category, you must be providing a service as per the employer's commercial contract with the final consumer again. So you can't be subcontracting. This has got to be a direct contract. Again, the contract cannot exceed 12 months, and the worker must have been with their existing employer for at least a year at the time of travel and have at least 3 years professional relevant experience and hold a relevant qualification if applicable to their job. For example, if an engineer, they either need to have an engineering degree or level 4 H&D, whichever is applicable. And they cannot receive EU remuneration, so they cannot be remunerated by an EU body whilst there. And again, if the service that they're providing is not found within the trade agreement, then they are not a contractual service supplier. They're out of the trade agreement, and it's likely they'll need to get a generalised work permit and seek permission to work in that country with the national authorities, as they're not covered by the trade agreement. And then lastly, intra-corporate transfer. So secondments, so an internal employee being transferred to another employer within the same corporate group. We know what these are. And under the trade agreement, the ICT must have been employed immediately preceding the transfer date for at least a year, and that's for management specialists. However, if it's a trainee, they only have to be with the employer for 6 months. They define manager and specialist by length of service and the seniority. And if you're senior, you get 3 years max stay as an ICT. If you're a sort of graduate trainee, you get max stay a year, again subject to individual member state rules. So those were the different categories of worker. They're quite restrained. There's only 4 of them. It's obviously not covered by the trade agreements, so you will need to check with the national, with the country itself to see whether you're allowed to provide that service and whether you need a generalised visa or work permit to do so. So moving away from working and providing service, what about those who are just business visitors? And what I mean by business visitors, those who are simply going for a meeting or a conference, sometimes a trade fair. You're not actually working, you are simply travelling on business, your typical business visitor. And the trade agreement has provided quite broad but exclusive definitions of permissible and impermissible activities as a short-term business visitor that you can do. However, it does not have to be adopted by the country you're going to. So take this with a pinch of salt. So as a business visitor, you cannot sell goods or supply services to the public. You cannot receive remuneration locally. You cannot provide any service other than that expressly authorised under the trade agreement. You should not require a work permit, but could be subject to border control, which means you may be required to present documentation. Again, there's this 90-day rule period that we've all heard about. So if you're a tourist, so bear in mind, if you're a business visitor and you wish to go on holiday to Europe this year, bear in mind the 90-day rule is triggered in both cases. So you're allowed to go to the EU visa-free or work permit-free for a maximum of 90 days in any 180-day period at a time. But this is not 90 days per country. It's not 90 days in France, 90 days in Germany. It's 90 days within the Schengen area, the EU. That is your limit. And short-term business visitors do not apply to local licensing, qualifications, technical standards required for work. This just means, obviously, if you're not working, they're not going to care if you've got the qualification or not. To be honest, that doesn't apply to them. Again, I'd like to labour the point. Each individual member state can impose different requirements on short-term business visitors as they see fit under the trade agreement. And the permitted activities under short-term business visitors is that what they can potentially perform is what I've said already, which is meetings, conferences, and consultations, researchers and design, which is researchers only, marketing research, training seminars. So you can receive training as a business visitor in the form of observation and classroom, but you cannot receive practical training. Trade fairs and exhibitions, you can attend a trade fair, but you can't sell. And you can see there we've got sales and purchasing as well. We've got a buyer engaging commercial transactions for goods and services. So you can get the gist of what the difference is between a business visitor and someone who's actually providing the service. So we can see here we've got commercial transactions, tourism personnel, translation interpretation, and although this is all in the trade agreement, what we'd like to recommend is that any business visitor wishing to travel to the EU, they should check both the trade agreement and the member state's national website for clarification. In addition, as business visitor, just because you don't need a visa or a work permit, you will still need to present documentation and apply for entry at the border. Slightly on social security, Jenny, I hope I'm not running over, but I will quickly do these slides and then over to you for some questions. So social security, essentially it's national insurance. We all pay UK NICs as employees in the UK. There is a separate chapter on this because the general overriding rule is that if you're going to work in another country, you have to pay national insurance the time you're there and working. Now, they've got these new set of rules called detached worker rules. Essentially, a detached worker is Joe Bloggs, could be anyone. If you're going to work, there's a definition you can meet, which means you are covered by these rules. And essentially, these rules say that we're going to uphold the rule that if you're working abroad, you don't have to pay national insurance in more than one country. So the way we get out of paying national insurance abroad is that HMRC issue us a certificate called an A1 form, which when presented to the border control or local authorities in the country you're going to, they can see you don't need to pay national insurance whilst you're there because you pay it in the UK. It's really important you show that. Otherwise, you are at risk of paying Social Security twice, obviously in the UK and also at the time you're abroad. So having an A1 form, which is obtained from HMRC, that proves you pay UK NICs, to be shown when requested to prove that you are exempt from paying national insurance in the country whilst you're abroad. And we've got the detached worker rules here. A detached worker isn't a category of worker. It is just an employee for an employer that normally carries out activities in the same place where the worker is employed, but is sent to work temporarily to another state for a period of up to 24 months, provided they are not replaced with another worker. So you can see this definition can meet many, many people. So lots of things to be aware of. Jenny, I appreciate this is a good time to hand over you for questions if we've got any time for this.
Thank you so much, Alice, for that really comprehensive run through. Now, there's a couple of comments come in. So first of all, I just want to reassure the person who said, can we please have a look at the slides after the session, that the answer is absolutely yes. We will post them on our website with a recording of the webinar. So you will be able to go back and have a look at these for reference. But I suppose, Alice, there's another question to you, really. Is there another kind of central place or central recommended website that people should go to for reference about business travel?
Well, Make UK has a brilliant website for a start, where we've got lots of information on business travel, how to comply, social security, everything like that. So that would be a good starter, because we do have tools and guides there. Gov.uk has a lot of information on providing services abroad as well. However, to get the nitty-gritty detail of what exactly you need for your specific country, for your specific worker, there isn't a hub, because there is no EU-wide rule. You've got to go to the German national website for Germany, you've got to go to the French national website for France. They all differ. So there isn't one size fits all, there's no EU hub. Unfortunately, this is a case-by-case, country-by-country basis. So you will have to find the individual country's national website for more details on what exactly you need. Alternatively, Make UK can help as well.
Right, lovely. Okay, so it's also a case of just finding out some of those good signposts, isn't it? Now, here's a good one. So Charlotte's asked, how can you tell if a person is a business visitor or a service provider?
So as we ran through just quickly there, the trade agreement does provide quite a comprehensive list of activities a business visitor may be able to do. However, you need to check the country that you're traveling to see if they generally are allowed to enter as a business visitor to do these activities, which again is by the company's national website. If you're concerned about whether your worker is a service provider or not, just have a think about the arrangement here. Am I sending someone to go and do some work for a client as per a commercial arrangement? Then 99% of the time you are going to be a worker, you're going to be a contractual service provider. So that sort of explains itself on the tin. Where it gets quite blurry is, well, I'm going for a meeting, but I'm also going to see a customer at the same time. That customer experience takes precedent, and that's deemed as post-contractual. And therefore, any interaction with a client, supplier, or customer is going to be deemed work by the country, and therefore, again, you're going to be in that work permit bucket. It's not crystal clear, but we can guide members with this. But essentially, if it's customer facing, you're probably going to require a work permit. If it's not customer facing, it's internal, you're probably okay to be a business visitor. That's a broad framework to go by, but of course, country specific, either check the website or Make UK can help as well.
Lovely, thanks Alice. I've got a couple more I'd like to get through before we hand over to Lucy. I'd also like to say to listeners, we'll take questions further at the end, but we will run over for 5 minutes or so if we feel that we've got questions coming through and we want to answer them. And again, we'll post everything on the website, so don't worry that we're not going to get to your question, because we absolutely will, whether it's in the session or afterwards. But I've just got a really couple of questions from somebody called Aaron who's posted a few questions, and they say, how do I get a work permit for my workers and how long does it take, number one? And then there's two follow-ups. If I do get a work permit, can I then go and work in the EU anywhere? And then thirdly, if I need to send workers overseas to Europe at short notice, what do I need to do? So have you got that, Alice, or should I give them to you?
I might ask you the last two, but firstly, how to get a work permit. So a lot of countries outsource the process to a provider. So there could be a website that makes the application for you. In many cases, from experience with our current members, normally you will have to go to the London consulate or embassy to receive it in person and have an appointment there. And you asked about waiting times. Again, varies for each country. Could be up to 5 weeks or more, could be less. I mean, at the moment it's COVID, not that many people apply, it could be quicker, but waiting times do depend on the country. And of course, how many you're applying for. If you've got 10 workers, it's obviously going to be longer. But normally you'd have to go to the national website and make an application from there. Sometimes it's a notification portal, sometimes you have to make an account, or sometimes it's outsourced to a visa provider. So there's many different ways there. And once you get a work permit, it is per country. So getting a work permit to go to Germany, for example, isn't going to let you work anywhere else. You're going to have to get a work permit for every single country you want to go to. So there's no EU-wide work permit. You're going to have to get individual ones separately. Jenny, was there another question?
Yeah, there was actually. In fact, one's come in, and I think it's very closely related to what you've just said, which is, I live in the UK, I'm going to start again. I live in the UK, but work most of my time visiting clients across the world, mainly in the EU. Where you say I cannot now travel to different member states on a single trip, does this mean I have to return to the UK every time after every trip?
No.
before I can go on again? In other words, can I go from one to the other, or I've got to keep coming back?
You can still go to countries, multiple countries in the same trip, except bear in mind you will then have to get full work permits in advance before you make that trip. You're going to have to make full notifications. The easiest way to do this for a company to prepare, if you do have people going off all the time everywhere, you need to sort of focus on who is your mobile workforce. Do I have a group of people who are my travellers? Because instead of letting everyone go for a random business meeting, not knowing who's going where and what, it'd be good to try and identify a group that say, right, you are the travellers of my company. You are the people we need to get work permits for. You are the people we need to get A1 forms for. You are the people we need to notify the countries about. And therefore you are prepared, because this is not an overnight procedure, as you can probably imagine. It does take time to not just wait for a work permit or a visa, but to collate the documentation and to receive back the A1 form or whatever it is, and receive authorization. And if you condense that to a group that is mobile, it is much easier to manage, so that when someone does need to travel to multiple countries, you have all the prep there to make the notifications and receive the permits in advance before you go.
That's very clear, thank you. And just one tiny follow-up on the A1. Do you need an A1 form for each country then? Is that what you're saying?
Yeah, there's two types of A1 forms. So there's a single trip A1 form if you're just going to one country coming back again. And the A1 form has got to have that country on it and the dates you're going. So you can't just have an A1 form and rock up. The A1 form sort of say, I'm going to be in Germany on the 12th of April to the 30th of April. And then there's a single state, there's a multi-state A1 form, which is when, as we just said, if you're country hopping, you have to put all the countries that you're going to in that single trip on that form with the dates as well. So what it will be, your A1 form is going to reflect the period of time you're in that country for that individual each time you go. So it is a repetitive process, unfortunately.
Lovely, thank you so much. Right, I think we'll stop there, Alice, because I think we'd like to get on to Lucy so she can take us through the other way round. Lucy, you're going to take us through the rules on immigration. Again, we will have questions at the end, so please post them in the chat. Thanks, Lucy.
So this is the second section, really, when we're talking about inbound travel into the UK, looking at the immigration rules around nationals coming to work in the UK. So most of what I say, I'm really referring to EU nationals, as that is where there's been the biggest change to the process, but obviously it equally applies to non-EU nationals, overseas nationals more broadly. Jenny mentioned that you'll be getting a set of the slides. That's quite helpful. There's quite a lot of detail on the slides, and embedded in the slides at the end, there's a couple of links to relevant government guidance where you can find a lot more information about this, because we've got a relatively short period of time to cover an enormous subject. So I'm going to be just touching over the headlines, but hopefully you will be able to find plenty of further guidance and support if you need further information in due course. So the overview. I guess the first point to note is pretty straightforward and obvious one. The fact that the EU reached a trade deal with the UK hasn't altered the most important Brexit people issue, which is of course the end of the freedom of movement. So EU nationals and their family members are no longer free from immigration control, and they're now within the scope of the new immigration system if they want to come and live in the UK. I'm not going to have time, not going to plan to touch on the COVID restrictions, which are also in place, which impact massively at the moment on travel, inbound travel. Not going to talk about quarantine testing, that kind of thing, but they are probably the most significant restriction to travel at the moment, nothing to do with the immigration rules. But obviously, as soon as they become less troublesome and we can move more freely, we're going to need to get to grips with the new immigration system. Came into force from January this year, and applies to EU nationals and overseas nationals in exactly the same way. The immigration rules will depend, the rules that you need to look at will depend very much on whether you want to, for example, enter the UK as a business visitor and as a temporary worker, whether you're in fact eligible under the EU settlement scheme, perhaps you're a frontier worker or a skilled worker, or you may be coming in as an intercompany transferee. I'm going to very quickly look at each of these categories. The immigration rules obviously cover a vast amount of other circumstances, but I think these are probably the ones that you're going to come across most regularly in the work that you do. The last point on the slide is an important one to be aware of, that if you are an employer and you wish to recruit from the EU or more broadly, you're very likely to need to be a sponsor license holder. And this may be a new concept for you if you haven't hitherto recruited anybody beyond the EU, but going forward, it's very likely that as an employee, you may need to register with the Home Office to be a sponsor license holder. So if you think you might be in that category, don't delay, and perhaps think about your workforce and your needs for the future and establish whether or not you may need to register as a sponsor license. So we'll talk about that a little bit in the next slide. A lot of what I say will there'll be some similarities with some of the concepts that Alice has been talking about. This is essentially the flip side of Alice's presentation just now. So this slide is the UK rules about business travel. So EU business visitors into the UK. Alice has been talking about business visitors into the EU. This is the reverse. So the common theme is obviously that a business visitor cannot work. They're not allowed to take gainful employment. So they mustn't work. But as in the same way as Alice mentioned, there is a list in our own rules about business visitors' permitted activities. So most of, well, I put a few of them on the slide. There's quite a lot of them, but these are the ones that are probably most relevant. So a business visitor can attend a meeting, conference, seminar, that kind of thing. They can give a one-off or short series of talks, provided they're not commercial events. They can come over to negotiate, sign deals, that type of thing. At trade fairs, again, promotional only, they can't sell directly to the public. They can conduct market research, and an employee of a foreign manufacturer may install, dismantle, repair, service equipment where the manufacturer's got a contract of purchase or supply with a UK organisation. So if the EU business visitor if their activities are within the permitted list, are they in the rules, then they can enter the UK visa-free for up to 6 months. Our rules are slightly more generous than the EU in this regard. But just very practically speaking, the longer the stay, the more questions the individual is going to get at border control, to ask whether, to try to establish whether the trip is in fact genuine business. Equally, the more frequent or frequent repeat entries might indicate that the visit isn't in fact a business visitor. It goes beyond those rules. And the last bullet point, travel with supporting documentation, similar to Alice's comments earlier, the visitor is going to need to demonstrate at border control that they are genuinely a visitor, that they fall within these categories. So really you want a slew of documents that support that. At the very least, the EU business visitor will want a letter from the individual's country employer that might be visiting, setting out the reason for the visit, and an outbound or return flight details to make it clear that they are in fact returning home. So those are the UK rules about business visitors. I guess if you can't find yourself into those rules, then you're going to need to look elsewhere. And the temporary worker category mirrors some of the language that Alice has talked about before. This is a short-term business trip. If they're not a business visitor, then can they instead be a short-term temporary worker? It's the trade agreements concepts are important to this category in the UK rules. It's a possible post-Brexit option, I guess, for EU nationals. They've got to be employed by an EU service supplier. They have a signed contract with a UK company, and they can come for 12 months in which they can fulfill the service supply contract with the final consumer. So it's quite a narrow category. Before we kind of think about some other immigration categories, it's also worth pausing here to think about the immigration rules that apply to EU nationals who, post-Brexit, who may be able to take advantage of the EU settlement scheme. So this has had a lot of publicity. I'm sure many of you know all about it, but I just wanted to recap on it for those of you who are perhaps not familiar with the detail. So EU citizens who were resident in the UK by the end of 2020, they're effectively protected by the withdrawal agreement with the EU. So they can stay in the UK, they can live and work in the UK as they did before. They can have access to the retained rights they had to work, study, and access to public services. But whilst they had to be physically in the UK at some point before the end of 2020, the application is still open. So they don't need to have applied for settled status yet, but they have until the end of June to do so. And it's really important that if you have EU workers in your workforce, or in fact, if you know any EU workers, please encourage them to apply before the end of June. It's really a really important step for them to take. I think about 5 million applications have been successfully processed so far. So I think the message is getting out there, but on discussions with employers and other member companies of ours, there's still some concern that the workforce haven't actioned this. So it is fairly straightforward for quite a lot of people. Obviously not the case across the board, but it's a free online application. It's supposed to be quite straightforward anyway. Irish nationals don't apply. Obviously, Ireland has a long-standing arrangement under the Common Travel Area with Ireland, which predates the EU. So Irish nationals don't need to apply under the EU settled status scheme, and they can live and move freely between the two countries. The last couple of bullet points kind of pick up on what the requirements are a little bit. An EU national who can establish 5 years continuous residence will be granted what they call settled status. If you've not lived in the UK for 5 years in a row, they'll get something called pre-settled status, which is a kind of holding status. Gives them permission to stay, and as soon as they clock up the relevant 5 years, they can then apply to switch to settled status. How does it work? It's a process based on proving identity, residence, and a quick criminal records check, which is done behind the scenes. So individuals are basically asked to provide they're asked to provide their national insurance number, because this enables the system to do an automatic data check. And if there are 5 years worth of tax and social security records, then it's quite an easy way to establish residence in the UK. And if that check proves positive, then that's all the documentation the individual needs to produce. If they can choose not to give their national insurance number, and an individual can demonstrate their residence in the UK using other documentary evidence. They might not have a complete tax record, for example, and they can prove their residence in the UK by reference to, for example, utility bills, bank statements, national insurance documentation, that kind of thing. Sorry, my email's pinging in the background. That's annoying. That's how the individual can demonstrate residence. Again, if they will get settled status, if they're in the UK for a continuous 5-year period, this continuous residence, so that's 5 years in a row, and as long as they've not been outside the UK for more than 6 months in a 12-month period. So they both have to have been here for 5 years, but also not been out of the UK for too long in that period of time. And once you get your settled status, you can spend quite a long period of time outside the UK without losing that status. I think it's currently 5 years, maybe reviewed. There are exceptions for this absence. I put on the slide this important reason. So if you have been out of the UK for what the Home Office considered to be an important reason, usually childbirth or serious illness, then there are some exceptions to that reason, that absence. The last couple of points on the last point on the slide, potential difficulties if you previously lived in the UK but spent substantial time abroad. This is really kind of a COVID point. We've been discovering that a lot of EU nationals who were planning to apply for settled status have gone home to sit out the pandemic, their home country, or equally some people who were planning to relocate to the UK before the end of 2020 didn't manage to do so because of the travel ban. So there have been some individuals who have been adversely affected by their absence due to COVID, and it's possible the Home Office will make some concessions in this regard. There's a picture on the slide there of the Home Office guidance document. I think you might not be able to tell, but I think it's something like 164 pages, which I have attempted to summarise in one slide. So if you have any questions or concerns, whether you're for yourself or for family members or staff, then please just browse this voluminous document, which will give you all the answers to everything about the EU settled status scheme. But it's really important, if you are an employer of EU nationals, to ensure that as many of your staff who are eligible do make an application under the scheme, and ramp up those communications and with your staff right up until the end date of June. Another question which is quite topical around EU settled status is the right to work checks for these individuals. We're getting quite a lot of queries on this, and it's an issue as to what does an employer need to check for EU nationals post-Brexit. Right to work checks have been around for a long time. It's in place because it's an offence under the Immigration and Asylum Nationality Act to employ an illegal worker, and employers have obligations to do some right to work checks to prevent illegal working. And if the employer carries out a sensible check of the relevant documents, they can establish what is called a statutory defence, or it's a defence. Failure to do so can individuals can be employers can be fined potentially up to £20,000 per illegal worker. So it's quite a big deal, and it's quite straightforward to establish defence by carrying out the right to work checks. At the moment, those right to work checks on EU nationals are just simply asking for a copy of their EU passport or identity card, and they will continue unchanged until the end of June. And so this means that even if you do have a workforce of EU nationals who have applied for settled status successfully, you don't need to seek proof of that. If you recruit somebody now, you don't need to ask about settled status, you can simply accept their EU passport. Employers will have a statutory defence, even if it does turn out that the individual didn't have the right to work. And the words in italics are from the Home Office, recently saying, look, the criminal offence of employing a legal worker is reserved for the most serious of cases of non-compliance. It's not intended to pick up the right to work scheme for EU nationals right now in this period of time between just recently exiting Brexit. So keep going with the right to work checks, they remain unchanged, but equally encourage your staff to apply for settled status. You don't also need to carry out follow-up or retrospective checks on individuals. So anybody who you think is eligible for settled status but hasn't applied, you don't need to chase them and ask them, but you can in fact do so should you wish to. Again, the wording in italics is from the Home Office documentation in this area. I'm going to quickly counter through a couple of other immigration categories. Again, frontier workers, this will be similar to some of the comments that Alice has mentioned. This is where you've got an EU national who was in the UK working before the end of 2020. So it's similar to the EU settlement scheme, but they were not living here. If they were living here before the end of 2020, they'd be eligible under the EU settlement scheme. But frontier workers were working here, but they didn't live here. So kind of think of a cross-border commuter, perhaps a French national who travels to work in London on a frequent basis. So they're not eligible under the scheme, the EU settlement scheme, but they are classed as a frontier worker, and they can continue to do work in the same way until June. And after that date, they will be required to obtain a frontier worker permit, which will last 5 years and will give them opportunity to carry on doing exactly as they're doing. If they were not working in the UK, they're not classed as a frontier working in the UK until the or they arrived after the December cutoff date, then the new points-based system will be the system that is applicable to them. This only applies for those who are working in the UK before the end of 2020. So if you can't squeeze yourself into any of the other categories, then we're looking at the points-based system, which is in place from the 1st of January. The way that UK employers hire is changing, and the system applies to EU nationals and non-EU nationals in exactly the same way. So if you're used to recruiting from overseas, you'll be familiar with some of these concepts, but if you've previously just relied on a local or EU workforce, then things are going to be changing. As the name suggests, it's a points-based system. Individuals score points, and visas are awarded to those who have enough points, and 70 points is the magic number. I mentioned before that lots of employers will need a sponsor license in order to access the points-based system. And the two main visa categories are likely to be the skilled worker category and the intercompany transfer visa. There are lots of other different work visas under the points-based system. They include things like sole representatives, startup, global talent. There'll be a new graduate scheme coming up in the summer, but I think the most likely ones are going to be the skilled worker route and the intercompany transfer route. So we'll just have a couple of minutes on each of those concepts. The skilled worker route, an employer who wants to hire from outside the UK will most likely be looking in this area, and there are various requirements for these individuals. The applicant has to have a job offer from an approved sponsor license, which is you, the employer will be the sponsor license. The job offer itself has to be at a required skill level. It's got to be at A level or equivalent. It's not the job, it's the job that's at that level, it's not the individual's qualification. So just because the applicant has A levels, it doesn't necessarily mean that the job on offer is at the right skill level. All jobs have what they call a standard occupational classification, a SOC code. If you're unsure about whether the SOC code and the designated skill level for the job that you're looking at, there's a huge list on the Home Office website about all the SOC codes, what skill level it is, and that's, the Home Office has a list of all these different job types and what qualification levels there are. So there's a lot of information about all of this on the Home Office website. So a job offer, 20 points, the relevant qualification for the job, 20 points, and then you get another 10 points if the applicant is an English-speaking can meet the English language requirement, which can be met in a number of ways. They could be from a native English-speaking country, pass their degree in English, that kind of thing. And then the last couple of bullet points on the slide are around the salary for the job. So you've got 20 points for the job offer, 20 points for the skill level, and 10 points for the English language requirement. You need another 20 points from essentially the salary of the job on offer. And that the salary, the level of the salary will depend a little bit on the job in question and the applicant's qualifications, but essentially there's a base threshold of 20,480, which obviously means that there is no general route for low skill, as you know, for recruiting from outside the UK for jobs offering a salary below that level. So if you're looking to recruit somebody into a position and the salary attached to that role is not above 20,480, in fact more likely over 25,600, then this route will not apply, and you will struggle probably to recruit them through the points-based system. Intercompany transfer is quite similar to the skilled worker route. Again, we're looking for another 70 points. It's used for existing employees who are being transferred by an overseas business whom they work for into a skilled role with a linked employer business in the UK. Workers again need to be sponsored by the UK employer. They'll need 12 months experience in the overseas company, usually at graduate level. And again, the salary for an intercompany transfer is pitched quite high. It's 41,500, or the going rate for the job. Sorry, should have mentioned that for the skilled worker route as well. There's a salary threshold or the going rate for the job, whichever is higher. So if in fact you're recruiting into a job with a significantly higher salary as a going rate, then that's the salary you need to pay. This concept of going rate, again, there's lists and explanations and guidance in the Home Office website about how you work out the going rate for a job. So that's the intercompany transfer. I've mentioned a couple of times about the need for the employer to be a sponsor license holder. In order for you to bring workers into the UK under the skilled route or the ICT route, then the employer must be a sponsor. Sponsorship basically plays two key roles in all of this. It provides evidence that the worker will be filling a genuine vacancy in a skilled occupation in the UK and will be paid at the appropriate rate. So you've understood the thresholds, the salary threshold, the skill thresholds, and it's confirmation that those are all targets being met. And it also involves a pledge from the sponsor that it accepts the duties of sponsorship, which basically is talking about compliance obligations. There are a number of compliance obligations embedded within the system, and duties on certain members of staff, including reporting changes to the Home Office if an individual's sponsored worker's role is changing, if they go absent, or if they don't turn up for a particular reason. There's quite a lot of obligations, compliance obligations embedded within the system. If you already hold a sponsor license, then just because the system has changed, your license is still valid. And if you are thinking that it may be time to sign up to be a sponsor license holder, then it might be worth getting on with it. It could take up to 6 to 8 weeks. It's not as Alice mentioned before, because of COVID, there's not a lot of activity in some areas, and there isn't much of a backlog at the moment on sponsorship applications, but I dare say there will be more and more going forward. The last point I've touched on before, it's important that you think about whether you need to become a sponsor license as an employer to bring in skilled workers from overseas, but there are ongoing compliance obligations, and it's not just the responsibility of the HR department. It really is an organisation-wide set of obligations. I'm conscious of the time, and so I want to just give you a couple of links to where a lot of the information around these rules are. So the second one is the business visitor rules. I mentioned that I put on the slide a handful of the rules, but there are more. So if you are expecting visitors from overseas, please do familiarise yourself with the permitted activities. It's very helpful if you can squeeze the activities into the rules. That way that it's less complicated as far as visas are concerned. And the first bullet point, that's a link to the broad set of guidance around the immigration rules. So that was a hugely fast counter through immigration in the UK. My next slide is a shameless plug, by the looks of it, for further support that Make UK can offer. I know that you've had an IR35 session with my colleague Sarah Brett. There's also quite a lot of GDPR activity in the next coming weeks and months with Make UK. There's a webinar coming up to do with key HR issues, and they'll be looking at the kind of recent ICO guidance around subject access requests. They'll be looking at the impact of COVID on health data and home working. Second point is about our fabulous suite of GDPR compliant documents that have been updated post-Brexit. And then we touched on IR35, and then gender pay reporting. That's the next big thing that might be applicable to you coming up with an April reporting date. I am ready for questions if you have any. Equally, I'm happy to take them by email later, whichever suits you. I don't know how you're doing for time, Jenny.
Thank you. We've got a few minutes left, and I just wanted to thank you very much, Lucy, for that absolute gallop through what sounds like huge amounts of documentation and guidance in this newish and changing area. So thank you so much for that. Just a reminder to our listeners, we will post the slides, post the links. I noticed that we had your date slightly wrong for the IR35 webinar. I think it was the 21st of April, so I'll amend that in the updated slides for the website. But just a couple of questions, and it's not completely clear to me whether or not these are better for you, Lucy, or one or two of them might be good for Alice if she could come back in. But one that is coming, which is interesting, which is so do employers need to be asking their existing EU national employees to provide evidence of their settled status then, now that we've changed everything?
I'll take that. This is a really good question. That's one that comes up a lot, and our members are certainly they're not confused by the rules, but they're perplexed as to why they would be. The rules do not require employers to ask their staff to prove settled status at the moment. At the moment, we're in what we call a grace period. So the period from January to the end of June is what the government and the immigration laws are calling the grace period. So in this period, you don't need to ask your existing EU staff to tell you whether they've applied for settled status, whether they're going to apply for settled status, whether they've applied successfully or not. It's simply not something you need to find out about. And equally, you shouldn't be making that kind of conversation mandatory, that kind of information mandatory. However, it is obvious how useful it would be to employers to know what percentage of their workforce have in fact successfully applied. And what we're saying to certainly our member companies is, whilst you can't require this information, you should certainly do your best to support your staff to apply if they're struggling in any way. You should encourage them to do so. You should really ramp up your communications about the EU settlement scheme, as you know, certainly in the coming months before the scheme closes. So technically, you don't need to ask. It would be pretty helpful if you knew, but you have to try. You have to tread that fine line of supporting, encouraging, perhaps asking if they're willing to share, but not actually require. There's no legal reason for you to need that information at the moment. So as a result, you shouldn't be necessarily asking for it. But if it's volunteered, it's handy information to know.
Thanks, Lucy. And then another one, you talked quite a bit about sponsor licenses. Can any employer apply for a sponsor license, and how much is it to apply? Do they have to pay?
Yes, unfortunately, the cost attached to immigration are going up and up and up and up. The answer to the question, can anybody apply for a sponsor license? Then yes, you have to be in a UK established company. You have to kind of approve your establishment, and as long as you haven't fallen foul of the Home Office in previous life with a black mark, then you should be able to apply successfully for a license. In terms of how much it costs, depends on the size of the organisation, the number of recruits from overseas you might want to appoint, but you're looking at in the region of £1,500 for a license. But then on top of that, there are other costs as well. Once you've obtained your license as the employer, you then have to provide perhaps the immigration surcharge, which is another £200. There's various application fees for visas, which will vary a bit depending on the nature of the individual. Employers often support family members as well. So we're not just talking about the main applicant coming in with the costs attached to them. Employers will often bring over and pay for all their dependents. So you can be talking about many thousands of pounds to bring a skilled worker in under the new system, and it's not going to get any cheaper. So yes, it's a serious consideration, serious lot of money, and adds quite a bit to your recruitment bill if that's the way that you need to go.
So I suppose just thinking about what Alice was talking about in identifying your travelling workers, identifying your key people, it sounds to me like some kind of kind of mirroring activity might be useful on that score, mightn't it, as well, really, when you're thinking about recruiting or thinking about using labour from overseas.
It is. It's looking, firstly at understanding who you've recruited in the past from overseas and why have you struggled to fill your vacancies with local labour. And the starting point is if your vacancies tend to be in lower skilled roles, then you're going to struggle to recruit from overseas anyway. If they're more skilled roles, because their jobs and they're in a shortage, your job is on a shortage supply list, you struggle with recruitment, then you are going to be looking for filling those vacancies with overseas workers, and you'll be able to meet the requirements of the scheme most likely, but it will cost you and it will take some time to get go through the hoops of applying.
Yes,
so yes, mapping out your workforce and your future needs is going to be really important.
Definitely having some kind of strategic approach to it. Now, here's a good one, and I don't know whether it's best for Alice or for you to take this, Lucy, but Brian Robinson says, we use a number of contractors to provide corporate services to our organisation. Are we able to meet with third-party suppliers under the business travel category, i.e. visa-free? I think Alice might have touched on this.
Yes. Hi, Jenny. So really good question. Hi, really good question. So normally, as a rule of thumb, if you are going to be meeting with suppliers, customers, or clients, and it's post-contractual, so you've got an existing agreement in place, that will normally be deemed as work and require a permit. However, it does depend on the nature of the task and the country. So, for example, it may be allowed in one country, for example, but in another country they might say, well, actually, no, we want you to have a permit for that. I'll give the example of Austria. They're very strict on what businesses they can do. And in Austria's case, unless you're meeting with someone internal or it's a potential client and it's a pre-existing contract, then you'd have to get work permits to do so. So be careful on that one. We can offer further guidance if you need it.
Thank you very much, that's useful. And there's a kind of similar one here as well from Gail Charlie, which is contemporary workers come and go between the EU and the UK with a 12-month visa, or the 12-month visa, she says, actually. So.
Sorry, were you asking about the existing visa?
Oh, I don't know. I don't know. Take that one, or whether we need to come back to that. But I think she seems to be thinking, can people just kind of come and go, or, it sounds like you've set out some very specific prescriptions around that kind of activity, so quite possibly not.
I mean, outbound, we've covered, if you're going to be working as a temporary worker, you'll be needing the relevant permissions, such as a work permit or residence permit, the notification, the A1 form, so you will need to get a valid authorization type of immigration document. Inbound, Lucy's already covered. There are various routes in, but again, you can't jump on a temporary basis. It will either be tier 5 or tier 2 unless they meet the business visa requirements. But I think Lucy,
yeah, I think once you've got your permission, you can come and you can travel freely, as it were. You can have a multiple number of entries on the same visa category, but yeah, you still need to go through the hoops and the authorization for your primary purpose of a visit. But you can travel. Once you're in, you're not stuck here. You can move freely within the rules of the particular category that your entry clearance or immigration clearance gives you.
Great, thank you. And then here's a good one. I think this is possibly one for you, Alice, from Bill. He says, what is the situation for UK nationals who have permanent right to remain in an EU country?
That's fine. So depending on what they're given, if they've got citizenship, then obviously they'll be an EU citizen. If they're part of that country's settlement scheme, very similar to the one that Lucy's just covered for the UK, then they will have the right to live there, work there, and study there. However, that's for that country. Even if they've got the right to remain in Spain, for example, they can't just go and work in France. So this applies to EU member states as well as the UK. If I was German and going to work in France, I'd still have to comply with the French rules on this, even if I was German. So these rules are already in place for European nationals. slightly less onerous than ours, I have to admit, but it's not a free-for-all. Work travel has always been regulated and still is. So whilst you may be able to work in the country you are, you will still have to comply with the regulations if you want to work elsewhere.
Right, so it's always check the rules, basically. It seems to be the kind of sense of that. I've got one final one, Lucy, that I think is for you, which is, you spoke about frontier workers. Do frontier workers have a right, do frontier workers have to return to their home EU country regularly?
Yes, but our rules are quite generous, actually. So a frontier worker, if you remember, is somebody who had been working in the UK before the end of 2020, but they live in an EU member state, so they're a kind of cross-border commuter. Our rules, UK rules, don't set up too many details around the frontier workers' pattern of work. They're not allowed to be in the UK for more than, I think it's 120 days in the last 12 months. So they need to return to their home country at least once every 6 months. It's not that often. It's not like every weekend. They're not restricted to kind of working in the UK during the normal working week and then home at the weekend. It's not that prescriptive. I know it's not the same necessarily looking at from EU countries, but it's not that often in our case. A lot of the issue around frontier workers is what they're actually doing, not really how long they're in the UK for. You have to really look at the activities in question, and are they actually doing, what kind of work are they doing? So it doesn't tend to be the duration of the stay that causes an issue. It tends to be the nature of the activity of the work involved.
Got you. Okay, thanks ever so much. I think that's all of the questions that we've got time for today, and I can see people are going back to their desks and starting their afternoons at work. So thanks to everyone who sent questions in, and huge thanks to Alice and Lucy for helping us to navigate these really, really key changes that are going on, and obviously there's lots and lots to get our heads around there. So grateful for all of the links and the further advice that you've given us on pointers for more info. We will get back on any questions that we haven't fully explored, and I'll put some of the questions that have come in front of you, Lucy and Alice, and maybe we can print some of the answers that we've given today just for further info alongside the links. I've got a couple of short notices before we go. As usual, our Insight Hub is jam-packed full of info, including our latest good practice guidance, policy and research, all on our website, and of course our special section on our site where we keep our coronavirus resources, which we do update regularly, so do keep an eye out on them. And then a little plug for our Pay and Prospect survey, which is open until the 19th of March. That's Friday week. And with so much going on in our market in this last year or so, it's really, really important that we get the best picture of what is happening as possible. And of course, that starts with you and your experiences. So please help us to develop that. And if you just go type in Pay and Prospects on our website, you will get to the survey, and it takes a little while to fill it in, but it's quite quick. We will return to our final webinar with our friends at Make UK before Easter. And so in 3 weeks' time, on the 31st of March, we will bring you a very, very timely general update on changes to employment law, which of course will be commencing the day after, 1st of April 2021. So put that in your diaries and look out for further details on our website. And we will, of course, be back next week at the same time, same place, where our London Region Chair, Cathy Hayward, will be joined by Richard Gregg, Operations Director of Saracens Rugby Club, for what is bound to be a thrilling conversation if you are into rugby, but even so for the facilities and workplace experience of managing that club will be really, really interesting. So do join us then. Thanks again to Alice and Lucy, and to all of our listeners. Don't forget our recording is available on the website, and from all of us at IWFM, have a great week. Bye.